Okay, I think one of the strongest arguments for federal level shareholder empowerment measures is that they address agency costs in a way that are unlikely to be addressed at the state level, since the board and management are the ones who choose the state of incorporation, so the states don't have an incentive to address those in the same way. So what are your thoughts on that as the reason for federal level things, rather than that they'll lead to a higher...
That is Lucian Bebchuk's one of his arguments. Yeah. But if you look at shareholder proposals, right, shareholders are actually not interested in having them reincorporate. So if you look at, there are thousands of shareholder proposals every year. There's virtually none of them are shareholders wanting to reincorporate. Right? And if they wanted to if they thought that was the problem, and that it's bad, say, to be in Delaware, let's reincorporate the North Dakota statute, or something that looks more shareholder friendly, we would find that. There are like 4 companies which had proposals like that over the past several years. They get no support from institutional investors. So if institutional investors, and they're aware of the agency problem, they support, you get majorities to get rid of any defensive tactic when they're put up. So I think that is really sort of I think that is sort of a red herring question to say that this is what institutional investors think is the problem. I mean, Delaware has done some things, obviously prompted by institutional investors' concerns on proxy reimbursement, majority voting, and the like. So they've done some of that. When although the shareholders can't initiate and say you have to move, if that was an issue, they would be putting that in the proposal process. And it's very hard for a board to ignore proposals that get majority support or even high levels of support over time, because that makes them an attention of a hedge fund, right, if they're poorly performing as well, because they know there's going to be support for their opposition. So that is one justification, or that would be a justification not actually for substantive content, because if that was the real concern, all you need in federal law would be to say, let's give shareholders the right to initiate a reincorporation proposal, so that they could do that without having the board approve that as well. So if that was the only thing that we thought was the issue of an agency cost in the choice of state, that would be the one thing that you would put in. There are some arguments about, for competitive federalism, you might want something at the federal government level that enables or facilitates or fosters competition. So if one thought that was the problem, I would say that would be the answer. I would say rather than have these 12 things, let's just put up something that says shareholders can adopt the reincorporation proposal. But as I said, I don't think that's really the issue that shareholders see on this, because we don't see the ones who want this saying, well, okay, let's just get out of Delaware and go to North Carolina that incorporates these things. Though, to give a criticism of what I just said, of course, Delaware is a lot more than the statute, and you might not, even if you thought the North Dakota statute was better, you're not going to feel comfortable if you have to adjudicate something that needs interpretation with the North Dakota court as opposed to a Delaware court.
The problem with agency cost arguments is that they ignore the fact that accountability and authority are ultimately incompatible. You cannot constrain agency costs without constraining the board's authority to make decisions. And so what you have to ask is, yes, agency costs are bad, but agency costs are the inevitable consequence of empowering people with discretion to make decisions. And so the question you have to ask yourself is, how much regulation of agency costs do we want? In what form? In what location? And of course, the problem with the current proposals that are on the table is that what we do not have is any sort of coherent package that's designed to address agency cost issues. What we have is a hodgepodge of ideas that's been pulled from various and sundry places and sort of whacked together with duct tape and baling wire. And so, whether or not you think there's a role for the feds in regulating agency costs, certainly the package of what we're looking at now, I think, can't be justified on that ground.
Great. We just have 2 minutes left, and let's get our last question.
There was a lot of talk before about proxy battles and the costs to shareholders. One significant cost that I think the panel hasn't discussed yet is SEC approval of the content of proxy solicitation materials, including a phone script. I've been in the trenches of these on both sides, and for people who don't know, you can't call your opponents bad names. The SEC won't let you. If you accuse them of doing bad things, you have to give them a big pile of proof. So they're almost adjudicating in advance, whether you're calling, Bernie Madoff a Ponzi schemer. Is that something that should be regulated nationally, or is that something that each state should have its own rules on the content of proxy battles?
Let me start on that, and I think what you're referring to is frankly much more of the old system of the review of proxy statements, because under the old system you couldn't put an ad in, you couldn't do anything, you couldn't use a script without it being approved by the SEC and being passed by them. Today, frankly, the only thing that the SEC gets to approve, and it will claim it's not approving, but the only thing it really passes on is the proxy statement itself. Other communications that are made have to be filed, but they don't get pre-cleared by the SEC. If the SEC, if one of the proponents has an issue with something, the other proponent says the SEC may write a letter, but at the end of the day, there hasn't been an enforcement action on a proxy contest matter in a long, long time. What the SEC will say is what happened in CSX, go sue. If you think that they're not telling the truth, then you have a mechanism, we've got a rule, and you can go in and pursue that action. So I actually think that the SEC process is not as overbearing as it used to be. I think that they are resource constrained. They're trying to use their resources appropriately. At the same time, by reviewing the proxy statement and making sure that people sort of are trying to tell the full story, I think that there is some benefit to having that. I think putting that in the states, frankly, and saying you couldn't legislate it, and you wouldn't want 50 different states having the ability to sort of pass on proxy disclosure. You always have the right to go into the court to sue, but you're going to generally sue based on the federal proxy rules, not on the state disclosure requirements.
All right, a vote for federal from the deal lawyer.
Yeah, I would agree from the perspective of having represented activist investors running several slates. David is correct in terms of the descriptions of what you have to file and so forth. There are virtues in making sure people do stick to the script and don't start ad-libbing or adding their own views in terms of why one ought to vote for something or not. I had one example of that a couple of years ago where somebody did that 2 days before the meeting, and I got a call from the SEC about what is this document that we see that says the following things. So what happens when you don't talk to your lawyer. And so we had to file a corrective document and pass out copies at the annual meeting the next day. I mean, there are reasons for trying to keep it as clean and keep it as straightforward as possible. And I think you're also dealing with a compressed time frame. It's like a campaign. I think it's difficult if you had to satisfy more than one regulator. It would be much more costly.
So I'm going to put in, not surprising since I've already written on this, that actually I think this should be a matter of the states, but I think if one did this is misleading to say 50 states, because what I've advocated is if you were to make this workable, and actually this is what I think, we want competition in securities regulation, but the issuer has only one state that could regulate the proxy access. So if my securities state that I've chosen is California, then they would set up everything that you're describing the SEC does. California can choose what it does, and Nevada chooses what it does, and Delaware chooses what it does. But your investors don't get the rules based on where they are, which is the current jurisdictional rules. We would import internal affairs jurisdiction into the securities area. And if you did that, then the issues about, oh, well, we don't know what we're going to say in one place or the other would go away because it's just that one state. And if it was better to have scripts versus not scripts, one might have some experiment across those states. Now, there is a sort of, question if we think shareholders don't have the same views about proxy fights being good or not. And this is, I guess, Steve's colleagues have written these papers saying that hedge funds and those people's interests are not the same as other individual investors, then that might be a question about the choice of these rules, because and this is sort of the same as the takeover context, are we going to choose rules that make it harder for people to communicate than not communicate? But in general, I would I would support what I think it's certainly conceivable that you could have this be devolved to a state level.
I think we're going to have a tie here. Last word, Professor Bainbridge?
The job of a corporate conservative, like the job of any conservative, is to stand on the train tracks of history shouting, stop. And so I'm perfectly happy to let the feds keep what the feds have. I just don't want them taking anything else. So let them keep proxies, but keep their hands off, say, the reimbursement or proxy access.
Well, all right, you surprised me. Professor Romano is outvoted, but she stands tall. Let's thank our wonderful panelists.
That was great, Ken. Thank you for coming down to do it.